and read what the two cases say, Kemri and Omtata, caution or imperative, and what Conchella says, administrative. But then you look at the eventual verdict in Conchella, even when they say it's administrative, they set out the preconditions for that. And the question you want to answer is this, my lords: have those preconditions even been met, assuming even that you take it by administrative, for the Deputy Chief Justice to take up the tools of constituting a bench? Because that's the limited question that we are here to address and to guide this court. I make up an argument that none of those grounds has been met. For example, we sat in this court in the morning, and I know this question will arise subsequently when we deal with the application for recusal, where my lords say, no, you know, in the virtual courts, in the virtual system, we can sit on anywhere. I'm trying to paraphrase it, my lord, so if I get one word wrong, it's not for any ill intention. We can sit at any time. We can sit from anywhere. We can sit on any day. So that, can the Chief Justice, for example, be virtually absent? Is it possible that the Chief Justice of Kenya distinguishes herself as the first person to be absent virtually? Wherever she is, at home, in Europe, in Asia, in Australia, Kenya, wherever it is, can she be absent virtually? The answer is an emphatic no. That in the virtual space, it is difficult to justify absence. Is the Chief Justice disabled? At least, it has not been suggested by the applicant, nor the respondent, that the Chief Justice is disabled. And therefore, even looking at the Conchella decision, none of the preconditions cited there to justify the limb of administrative has been met. In which case, the Deputy Chief Justice has no basis upon which she could have taken up the gadgets to constitute this bench. In a virtual court, my lords, and we must be very careful about this, because I kept asking myself this morning, I've never been a judge, maybe one day I will be, maybe not, how uncomfortable it would be to sit as a judge when you perceive that some of the parties believe are uncomfortable with you. It must be a very frustrating situation to find oneself in, and my sympathies go out to all judges who find themselves in those circumstances. Just one into this argument. But the interface between litigants and the judiciary in this technology space is the CTS, the e-filing system. There are no directions from the Deputy Chief Justice in the e-filing system that we are interacting with. None whatsoever. Is the judiciary immune from the principle of transparency and accountability? It is not. If the Deputy Chief Justice makes such a consequential move as taking up the powers vested expressly in the Chief Justice, that's a matter she must, number one, expressly disclose by lodging it in the CTS for us to interact with. Number two, provide reasons for taking up that role in that direction. We ought to have seen a decision saying, for the following reasons I take up this role of the Chief Justice, then proceed to give directions. In the absence of that step, my lord, you have stood up as individual judges, as some of the greatest defenders of our Constitution. That character you have established in the past demands that you look at the Deputy Chief Justice in the eye and say, you may have been well-intentioned. You are. You fell short of the constitutional standard, and therefore by virtue of Article 2 of the Constitution, what you did was null and void. Our seating, the three of us at this bench, is null and void. We must down our tools at that juncture. Allow me to invite my senior colleague, Senior Counsel Paul Mwite, to carry forward and finish our argument. And thank you so much.
I will be very brief, my lords, your leadership. The taking of the court file 015 from Kirinyaga Court in the middle of the night was a gross irregularity that impacts on a fair trial. The bringing of that file in the middle of the night from Kirinyaga, Kerugoya, to presumably the Deputy Chief Justice, was another gross irregularity. For the Deputy Chief Justice to have sat in the middle of the night on Friday, the 18th of October, was a gross irregularity. The absence of communication from the Office of the Deputy Chief Justice to the parties in 015 was a gross irregularity. For your lordships and your leadership to have sat as a court outside the prescribed court days on a Saturday was a gross irregularity. The maxim that justice must not only be done, it must manifestly be seen to be done, is an extension of the right to a fair trial guaranteed in Article 50. This litany of irregularities contaminates the sitting of this bench irredeemably. And I would ask that in respect to Article 50, we do not even go into issues of recusal. Your lordships, your leadership should, on the basis of those irregularities, down your tools. And there is one I have forgotten. When this honorable bench was hearing our plea for an early date, this honorable bench said the earliest date they had was Thursday of this week. So now, with this litany of irregularities, this honorable bench found time to give a hearing today when they had said they are only available Thursday. Let justice be seen to be done. The only agency that one is able to trace is that somebody somewhere is in a hurry to vacate the conservatory orders that preserve the substrata of the petition on very weighty issues in order to swear in somebody somewhere as a deputy president. You are concerned with the constitutionalism. And permit me to point out with a lot of respect, my lords, your leadership. I have gone through these things during the radical surgery, and I doubt that we have seen the last of the radical surgery. And my plea is that you preserve constitutionalism, you preserve the dignity of this court, because the people of Kenya are looking up to the judiciary only. Preserve that, is a gain. I thank you.
May it please you, presiding judge and members of the court, we thank you for the opportunity to reply as respondents. Before I do that, I want to thank.
I thought you would be given an opportunity to find out whether we are with the forum meeting or not.
Yes, how many people are supporting the patient? Are you parties in this matter?
motor without a vehicle. For the second petitioner. So perhaps you're also allowed to submit or submit. Okay, thank you. So, Your Honor, I'm in support of the application, and the fact of the matter and why we are in support of it is, number one, as I said earlier, we were never served with those directions. And the fact that we were never served, this is proper procedure. That's any matter that is taken before a judge. All parties must be notified. We were never notified. So why we were never notified, and I had to learn about this issue today, I do not know. That raises eyebrows. And from the petitioner's side of view is, will this bench be impartial? Or we will be hard? Because if directions are being taken, petition E013 of 2024 is part and parcel. In fact, it was consolidated. We have not been notified. Why? Number two, the issue of fair hearing, Article 50, has been repeated over and over again. Isn't this a violation of the second petitioner's right to fair hearing? In fact, some of these applications, I'm getting them now. Yet, I should have been served before. Why the hurry? Why the rush? Why am I supposed to be served right now in court and I'm told 5 minutes submit? What is in stake? Let us all get a fair hearing. And with these preliminaries that are coming up, one is meant to wonder, will we really get justice? Petition E013, 2024 was filed before petition E014 and E015.
Council, just for your information, those were your orders to go from Kagoya, where
Yes.
the petitions were consolidated. So
Yes.
that must have been your application before that court.
Yes.
So don't bring it here.
Yes. But the issue is, even after it was brought here, it is being mentioned and we are not aware. So if a matter is going to be mentioned and we are not aware, then it only shows either the bench is ignoring us, or perhaps our petition has no merit. And why so, yet we have not submitted? Let us be given a chance. Let us be given audience, even to reply to the issues that are being brought forward. And we cannot reply when standing right now. I need time. I need 1 hour or 30 minutes or whatever. But I need time. So those are the issues why we are in support of this application. We feel that we are not being given a fair hearing. And the other issue that has been raised also, that the bench sat on a Saturday. We are not aware. We are learning right now. We know court operates Mondays to Friday, 8 a.m. to 5 p.m. This Saturday, when was this direction issued? Why were we not informed? So those are the bases why we are now joining hands. Though our petition has its own grounds, but then again, because of those issues, we feel if we don't raise this issue, then we might not get proper justice, because there are some people who, of course, are SDAs who are not able to sit on Saturday. We were not notified again. You know, those kind of issues. That's why we are wondering why the rush. Yes. Maybe finally.
We are on the application for empanelment.
Yes. Yes. That is the issue. The issue was that, and I've also talked about it, we were never informed. And any petition, any case that will be given direction, so long as I'm in it, so long as there's a petitioner there, I have to be heard. And that is the law. And there's nothing new I'm saying. This is the procedure all advocates use. Why is it that I'm being ignored? I'm being notified 11 a.m. watching television, and I was very eager like any normal Kenyan. I see my petition being mentioned. I was very angry, But I decided to take a vehicle from Kirinyaga County quickly to come before this court and inform the court that that is not fair. That is not fair, and Article 50 has been violated. And this being a constitutional court, kindly allow us to participate fairly. That's okay. Yes, my colleague can make notes.
Victor. Within the limited time that we sat with my learned friend, Mrs. Kimotho, and despite all those challenges, we have come up with about 4 points which we request that we be allowed to submit on, since we may not have more time to file documents in support of the application. So kindly, my Lord, give me 5 minutes. Your Lordship, the powers that are given to the Chief Justice to empanel a bench, as submitted by my learned friends, is not a power that can be delegated. In constitutional classes, which we have the privilege to be tutored by Senior Counsel, Professor Githu Muigai, he told us that there is a principle called delegatus non potest delegare. A delegate cannot delegate. So that the people of Kenya have delegated power to the Chief Justice to exercise that power. And the Constitution does not leave any room for delegation of that power. So now, we are before you, having been empaneled by a person who does not enjoy the people's power to empanel a bench. My Lord, this is a jurisdictional question rather than an administrative question. And from the decisions which have been cited by my learned friends, Kemri, Okiya Omtatah, and the Conchela case, one thing you learn is that in Kemri and Okiya Omtatah, the court said this is a constitutional function and it cannot be delegated.